Good afternoon to all of you. I take great pleasure in welcoming you, all of you to this webinar and we are organized jointly by CREDAI and Surana Surana. CREDAI, as you all know, it's a All India Organization for Real Estate Organizations, Confederation of Real Estate Developers Association of India. And we have 10,000 members across India, and in Tamil Nadu we have 5 chapters: Chennai, Coimbatore, Madurai, Tiruchi, and Erode. And as you all know, Surana Surana is a well-known international firm with a substantial practice in real estate and the infrastructure, and completed 50 years of legal practice, and ranked among the top firm in the 24 consecutive years. We are very happy to be associated with Surana and Surana and conduct this webinar. And today we have 2 interesting speakers as well as a panel discussion. So let me first introduce Ramakrishnan. He is the real estate executive for the last 30 years with the domestic and international experience. Well versed in all real estate operations and responsible and accountable for the entire real estate management as well as transactions. And he has successfully implemented full life cycle real estate projects worth more than $3 billion so far. And now let me also welcome Mr. Ramakrishnan, and let me also introduce Mr. Sanjay Mehta, who is a partner in Surana Surana, and he's the head of real estate practice for the last 20 years. And he has got expertise including structuring complex real estate transactions, documentations, private equity and capital market appraisal and syndication, and licensing with fund managers, bankers, venture funds, and other investors. And welcome Mr. Sanjay to this webinar, and I welcome all other panel members also. So with this few words, I don't want to waste much time, and I'll hand over to the Mr. Ramakrishnan directly so that he can get on to the subject. Over to you, Mr. Ramakrishnan.
Thank you, Suresh. Thank you very much. Thank you, everyone. I mean, I can just, Sanjay Mehta, thank you for organizing this. Balaji, my good friend, Sanjay Chab, Amit, Praveen, though I know you for a couple of days now, and Harsha, all of you. It's an eminent panel, I don't have to tell anything, you guys know the subject very well, and, you can be of great use to CREDAI. CREDAI, as Suresh told, is an apex body sort of, which governs everything that is related to real estate. And it's been for about 20 years, doing various good things for real estate developers. So anything, any issues or any good things that happen is all because of CREDAI's contribution to real estate. And of course, the important stakeholders in doing real estate business, we all know that, legal certainty is the important stakeholder. And it's, we cannot be more blessed than, having partners like Surana and Surana in doing business, because, whether we have to start the deal or we should not start the deal, So without your documentation, so we could not do anything sort of, that's a basic that anybody has to have. So while when I started, I didn't know that, how important real estate is in terms of, legal is in terms of real estate. That's about 30 years ago, all I thought was like, as an engineer, the guy who builds is very important. Slowly then I realized that, legal and finance is most important, and legal is much more important than anything else for us to do this business. So I also thank Mr. Vinod Surana, who is the sort of president and whatever CEO he is for this company. So I take pleasure, and I'm okay to go anything and everything that you may ask. I'll be happy to answer with whatever limited knowledge I have. while I represent Rahejas here, we are into all major four real estate segment. Like, we are in commercial, we are in residential, we are in hospitality, and we are in retail business. We are also in warehousing, and we are also in data center business currently. So we cover the entire spectrum of business as in real estate. So whatever I can contribute to this webinar, I'll be happy to contribute. So thank you so much. Thank you everyone for making me available for this. Mehta, you can just go ahead.
Great. Thank you, Ramki sir. Thank you, Suresh Krishnan sir, for this great introduction. Good evening, everyone. It's a pleasure welcoming you all to the 5th Surana Surana Knowledge Series. This webinar is part of the knowledge series conducted by our firm, Surana Surana International Attorneys, on current topics of interest and latest developments in the legal field. The audience for this series normally includes our clients, members of our partnering organization, in this case, CRADAI now, officers of various regulatory agencies we deal with, our colleagues, and budding lawyers who have either recently joined us or who are following us on social media. I'm grateful to CRADAI Tamil Nadu and other stakeholders in the real estate domain who are partnering with us in this webinar. I'm informed that the audience in this webinar includes large developers, landlords having substantial holdings, tenants who lease large multiple office spaces, residential welfare associations, financiers, officials of the regulatory authorities, and of course the small-time landlords who are hitherto not comfortable giving away their prime properties to tenants for various reasons. Also included in the audience are aggregators who would take bulk residential spaces either from the developer or from individual owners and then lease it out to bachelors on a per room basis rather than the entire apartment. The aim is to get experts within the domain to share their perspective with the stakeholders, to answer those nagging questions, to take care of the doubts which would come up, and then help our stakeholders to take an informed decision. Currently, this is on Zoom platform, but a curated version of this webinar would be hosted on YouTube, Facebook, and LinkedIn for future references. Now, coming to the main topic of today's webinar, the Union Cabinet on 2nd of June 2021 approved the Draft Model Tenancy Act 2021 in a move that is likely to revive India's rental market, more so the housing rental markets. Earlier, we had the Model Tenancy Act of 2015 and then the Model Tenancy Act of 2017. All these were under the aegis of Honorable Prime Minister's vision for housing for all by 2022. The government, by citing 2011 census, claims that around 110,000 houses were lying vacant in urban areas. And one of the main reasons for non-availability of these houses for rental purposes is the existing rental laws of states and union territories, which actually discourage renting. As land comes under state list under our constitution, now it is up to each of the states to enact the Model Tenancy Act into a law, of course, after modifying it to their respective local requirements, just similarly as how we did it for the RERA. In line with this requirement, the government of Tamil Nadu has already enacted the Tamil Nadu Regulations of Rights and Responsibilities of Landlords and Tenants Act 2017, repealing the old Tamil Nadu Buildings Lease and Rent Control Act 1960. This new act is based on the Model Tenancy Act of 2015. Subsequently, when the government of India shared the Model Tenancy Act of 2017. Improving on the earlier model, the state government of Tamil Nadu brought an amendment act of 2018 on 22nd February 2019. So subsequent to that, now we have this new Model Tenancy Act 2021, which further improves the earlier models. Let me quickly summarize the essence of the entire Model Tenancy Act. The first thing is a written agreement is compulsory between the landlord and the tenant. And the terms which have been agreed between the landlord and tenant are binding upon the successors of the landlord as well as the successors of the tenant for the remaining period of the tenancy agreement. It is also applicable only prospectively, and the existing tenancy laws or existing tenancy agreements shall continue to be governed by the respective extent rental laws of the respective states and union territories. While the parties are free to fix the monthly rents, the security deposits cannot exceed a prefixed amount based on the monthly rents agreed. For the first time, the role played by property managers is recognized in the Act, and the Act also lists down the duties of the property managers. The Act also lists down the responsibilities of the tenants and the landlords when it comes to maintenance of the property. Similarly, subletting is not permitted without an execution of a supplementary agreement between the landlord and the tenants. There are predetermined penalties on the tenant for overstaying beyond the period of tenancy. Recovery of possession of premises by the landlord are again specifically given on predetermined grounds. The Model Tenancy Act claims to provide for fast-tracking quasi-judicial mechanisms for adjudication of disputes. The setting up of rent authority, rent control courts, and rent tribunals are exclusively dealt with in the Act. I purposefully state that it claims to fast-track the judicial mechanism because in reality, it is different from what the Act envisages. From our experiences, we know that while many of the acts say that the intention is to fast-track the dispute resolution mechanism, but in reality, there are delays which happen for various reasons. For example, in this case, while the rent courts and rent tribunals have been functional in the state of Tamil Nadu, the rent authority is not fully functional. As per the Act, the state government has to appoint the rent authority. These posts are either vacant or the person appointed on these posts have other priorities and they do not attend to the issues emanating from the Tenancy Act. Similarly, there are other practical challenges in the way the Act operates. Now, to just quickly summarize the improvements which have happened in the Model Tenancy Act 2021 when compared to the Tamil Nadu Act, which has already been enacted, I will just list out a few very critical or very important amendments which would have to take place now. So when it comes to overstaying of tenants, while the Model Tenancy Act 2021, there is no explicit extension that the act, the agreement or the terms kind of get explicitly extended. Whereas under the Tamil Nadu Act, there is an implicit provision where the relationship extends on a month-to-month basis. This is predominantly taken from the old Rent Control Act, and it continues as of now in the state of Tamil Nadu. Further, the penalty levied under the Model Tenancy Act is 2 times the monthly rent in case of overstaying of tenants for the first 2 months, and 4 times the monthly rent thereafter till the tenant vacates. Whereas under the state of Tamil Nadu Act, it is only 2 times till the tenant vacates. For security deposit, the Model Tenancy Act restricts it to 2 months for residential premises and a max of 6 months for commercial premises. whereas under the Tamil Nadu Act, it's a standard 3 months without any distinction between the residential tenancy or the corporate commercial tenancy. Again, in the Model Tenancy Act, there are specific instances of force measures which have been listed, whereas in the Tamil Nadu Act, there is no such reference. The Model Tenancy Act further provides for non-payment of rent during force majeure event if the property becomes uninhabitable. And in case where the tenancy expires at a time when the area where the property is situated is affected by a force majeure event, then the tenant has a right to stay occupied in the premises for 1 month more from the date of cessation of force majeure event on the same terms and conditions. The Model Tenancy Act, the latest one, gives more role clarity for property managers. Apart from the earlier norms of landlord introducing the property manager tenants in a very explicit way, the purpose and the time period for which the property manager has been appointed has to be notified by the landlord to the tenants. Additionally, the rent authority has the powers to remove the property manager or even levy fine on them if they contravene the purpose of the appointment. While this is a new enactment and it would have its own teething issues, like any new thing, it would be our endeavor to discuss these challenges in this webinar with experts we have to provide the required clarity to all our audience and to see how best we can use this act for our advantage, whether we are a tenant or we are a landlord or we are part of that whole property management team, which could even include the Residential Welfare Association. So now, let me quickly introduce the esteemed panelists which we have in this webinar. I would request my colleagues that as I name the panelists, would request you to at least wave to the audience so that they are able to identify you easily. So let me start out with Mr. Praveen, Head Legal of Renault Nissan Technology Business Center. Mr. Sanjay Chugh, City Head and Senior Vice President, Anarock Property Consultants. Mr. A.G. Balaji, CEO, Olympia Group. Mr. Harsh Koda, Co-founder, Federation of OMR Residents Association, otherwise called FOMRA. Mr. Amit Raj, Head Operations, Tamil Nadu and Kerala, CBRE South Asia. And of course, our own Mr. Ramki or Mr. Ramakrishna Shankaran, as his full name is, Senior Vice President, Tamil Nadu, K. Raja Corp, and also an active member of CREDAI. Now, I would request if each of these panelists could please self-introduce yourself quickly in a minute or two, talking about your activities and everything. Let me start with Praveen. Do you want to introduce yourself? Praveen, you'll have to unmute yourself.
Thank you, Sanjay. Good afternoon, everyone. So happy to be here to discuss a new statute, the Model Tenancy Act, with esteemed panelists over here. To introduce myself, my name is Praveen, as Sanjay introduced me. I head the legal for Renault Nissan Technology and Business Center, India. Now we operate out of an economic zone within Chennai. So the act certainly has implications to me as a corporate, as an in-house counsel for the corporate. I look forward to share my insights and also hear the valuable inputs from the panelists over here. Thank you.
Sanjay, do you want to go next?
Good afternoon, everyone. I hope I'm audible, and thanks, Sanjay, for the introduction. My name is Sanjay Chugh. I head the Chennai business for Anarock Property Consultants. We are basically a residential consulting company where we become the bridge between a developer and a seller, the buyer of real estate. So we interface between them. And this act, which we have just come across, the Model Tenancy Act, I think is a path-breaking journey, at least in the buyer's perspective, who normally would struggle to find a solution to their renting problem. So I think it's a great opportunity for all of us, all stakeholders here, to discuss this act and have some takeaways from the discussion as to how it would help the buyer of a real estate asset and a tenant of a real estate asset, apart from us who are the service providers. So looking forward to all the views of my co-panelists and thanks very much.
Hey, Balaji, do you want to go next?
Yeah. So good evening, all. I'm Balaji. Good to be part of the webinar and be a panelist here to share some of the experiences and also to learn from other panelists. And I business as a CEO, and we have almost 10 million square feet of space across various segments delivered, and we have other spaces coming up to the tune of around 3-4 million in the pipeline. So I'm pretty happy to be part of this group and contribute to the webinar as well as learn from the webinar. Thank you.
Thanks, Balaji. Harsha, do you want to go next?
Yeah, hi. I'm Harsha Koda. I represent FOMRA, which is the Federation of OMR Resident Associations. For those who are not in Chennai, OMR is the IT highway of Chennai, and for about 40 kilometers, we have IT parks and homes and high rises. And FOMRA represents about 150 RWAs on this road, right from Madhya Kailash to Mahabalipuram. And we have about 60,000 homes, members of 60,000 homes who are part of FOMRA. We have the unique distinction in this panel of being both landlords and tenants. So FOMRA represents both. We are, as you would say, an unorganized sector, unlike all the other gentlemen here who represent large corporates and organizations. We are just a federation of you, me, he, she, and us.
That's a different perspective which you bring on, Harsha. Thanks. Go ahead, Amit. You want to introduce yourself?
Yeah, good afternoon, everyone. First of all, kudos to Kridai and Surana for actually having this panel. It's a very pertinent topic. I'm Amit Raja. I run the regional operations for CBRE South Asia Private Limited. For those who don't know CBRE, we are a global real estate consultancy firm. We are the largest at it, based out of the US. A Fortune 500 company. We are in the space of providing consultancy services for large corporates, funds, developers, landowners, and help facilitate transactions. We are in the property management space. That's a very large business for us, and it's pertinent in today's discussion. What I intend to bring to the dialogue here is the perspective of large occupiers and large developers who are looking at India very keenly, and what could be the potential pitfalls and challenges that could come our way as we go ahead and implement this act as state laws in the weeks and months ahead.
Thanks, Amit. Ramji said something quickly about your company so that people know you again.
Okay, I represent Rajas, state of Tamil Nadu. Rajas, as you know, that we are in the business for about 60 plus years, and we recently went on REIT. So we have the second largest portfolio in this country. We operate about 30 million square feet of commercial space, and subsequently, other areas where we are like hospitality, retail, and housing. So we are predominantly in the western region, South, Hyderabad, Bangalore, and Chennai, of course. We are currently implementing about 4 million square feet in Chennai, which is up for market around 2023. So our portfolio would be about 4-5 million in Chennai, given 2023, mid of 2023. So I mean, that's about whatever I want to introduce, and we'll just as it goes, we can just share our thoughts, how we operate our business and what benefits or what disadvantages we have with the Model Tenancy Act. Thank you.
Great, thanks. Now let me open up the floor for our discussion with the esteemed panelists. Audience, your questions in the chat box. Of course, we would have a live question and session in the end. But while we are discussing these issues, if you have any questions, you can push it onto the chat box, and our team would take them up and ask the respective panelists. Praveen, let me start off with you first. You're a corporate tenant occupying large office spaces. Just quickly, in 3 to 4 sentences, your views about the new Model Tenancy Act.
Now, as you rightly pointed out, the primary object of the statute is to regulate renting of residential and commercial purposes and to protect the interest of landlords and tenants. Now, when I approach the act, certainty and clarity are two things which come across to me, because you spoke about the various concepts like property manager, responsibilities of a rental agent, definition of force majeure, very relevant for the modern days, prescription of a maximum security deposit that can be levied. As you said, 2 months for residential and 6 months for non-residential, prescribing a mechanism for resolution of disputes with the intent of expediting the disposals of such disputes. Now, that's a great intent. And also Schedule 2 of the Act, which is very relevant, which distinguishes the responsibilities with regard to the landlord and the tenant with regard to the maintenance of the premises. Now, therefore, when I approach the statute, it offers a lot of clarity, lot of certainty. But then for practical purposes, for a corporate like us, now where lease agreements are generally for longer tenures and going by the prescription in the Registration Act where we are, these documents are compulsorily registrable, then the viability and the practicality of again going through yet another registration process, though with the intent to regulate with the rent authority in such cases, now that is perceived as a business hassle. And that's where now maybe we should share thoughts.
Okay, so just quickly, certainty and clarity, but then duplication of process. Fair enough, no problem. Harsha, you deal and represent both landlords and tenants in your unorganized sector, who many times do not have the same bargaining power as large tenants or landlords as Praveen has. So your views on this new Model Tenancy Act?
Sanjay, it looks wonderful as far as landlords are concerned, where you say it's a written agreement, you have it filed. I also like the fact that we can do it online. There are a lot of non-resident Indians, non-resident Chennaiites who have to register these documents. So for that, being online, great job. But for the 2-month deposit point, which is there, I don't think too many landlords are going to be happy about that, because 2 months does not cover the kind of damage that you can see in an apartment when a tenant vacates. I'm speaking on this topic, especially from OMR scenario, where we have a large, paying guest bachelor accommodations where landlords have had to spend almost a year's rent on repair after the tenant has vacated. So, it's like, it's a very difficult and sad situation, and 2 months deposit is not going to cover that. So I don't know how that we are going to work around. But I like the fact that there is a extra document required for subletting, which is a very big scenario in RWAs in OMR. This is a welcome thing that at least the RWA knows how many people are living there. See, right now, that's the biggest issue. With a family, you can say 3 people, 4 people, 5 people, you can say that. But when it comes to bachelors and paying guests and guest house accommodations, we have no clue how many people are staying there. So it becomes very difficult to manage the arithmetics when it comes to, calculating water costs and other costs of maintenance and stuff like that. So I'm very happy about that thing, that we have this extra document for subletting. Let's see as things reveal themselves if we have more points on that. These 3 things I like.
So to summarize, good for landlords, your online facility is good, you feel subletting, there's an additional document so the RWA know who's living there, but the security deposit is a dampener for you. Okay, good. Both Balaji and Ramki, you both are corporate landlords leasing to corporate tenants like Praveen. In quick 3 to 4 sentences, your view or take on the Tenancy Act. Balaji, do you want to go first?
Yeah. The Model Tenancy Act, as well as the earlier Act of Tamil Nadu in 2017, which got rolled out in 2019, both are definitely considered to be beneficial to both landlords as well as tenants as far as the Act is concerned. More specifically to commercial leases that are happening, to the tenants or the landlords, it doesn't make a big difference because predominantly these commercial leases are, for a period of 2 to 3 years starting with, and it can go till 9 to 15 years kind of leases. And these leases are generally watertight leases, taking care of all the clauses that are listed in the model tenancy agreement, or much more getting covered as part of the lease agreements. And those agreements are registered as per the Stamp Act. So there is very little possibly, over and above what is being done today, which could happen. But in terms of any dispute that is coming, yes, there is definitely a faster mechanism and a faster process to have it resolved through the rent authority or the tribunal or whatsoever the authorities are there. But those leases which are getting entered into for a period less than 11 months, which doesn't require a registration obligation as per the Stamp Act, that leases definitely get tightened with this particular act, and you register it along with the rent authority. So that becomes much more a secured lease between both the landlord as well as tenant. And majority of the disputes arise only in those kind of leases and not on big corporate leases. So from that perspective, I think this act is definitely going to be a boom. And I think Ramki can add a little more on that.
I think you said it everything, Balaji. It's just nothing but similar views for me as well. While we, because of this rent authority, we administratively we have to do something else, as Praveen said, that which is sort of duplicating or something like that. Which we want. If anything can be a bridge between to make sure that it's at one end we do everything and then it gets captured everywhere. It can help us, because today with the resources having a lot of constraints, and then companies not performing because of the pandemic and other things, every bylaws or laws is putting a lot of pressure on the available resources. So that's one thing which I want to otherwise I think Balaji has said everything.
Okay, so the takeaways are that not much when it comes to contractual obligations, which are much more better captured as per the old act and under the registration, this one. But yes, dispute resolution, you are happy with the mechanism which is stated there. It is also bringing in those shorter duration leases, which were previously going below the radar. Those are also getting recorded. But yes, the downside is duplication of processes. So that's fine. Now let me move to the international property consultants, both Sanjay and Amit. As mediators who help closing deals, do you think this act will facilitate a faster closure? Your views on this new act? Both of you, maybe Amit, do you want to go first and then Sanjay?
I wouldn't mind. For starters, anything that brings about transparency, anything that brings about a regulation and brings about certainty, to Praveen's point, it is good, right? But the only problem is how fast will that get formulated and implemented? That is what is going to be the most crucial aspect from a commercial point of view. There are numerous aspects in the current act that does not address fairly complex lease transactions that typically companies enter into. I can get into some examples that will give you some idea probably later on during this discussion. But then the general need to regulate is very strong. I think from a transparency index point of view, this will be a very important milestone for most of the Indian cities to jump up the radar. And hopefully, if implemented, this will be very, very good. Change of any sort is certainly going to be painful. obviously we will have to go through that pain together as one team for us to achieve this. The current aspect of the slightly intrusive nature of putting limits on the commercial terms between which a landlord and a tenant can enter into is, I see that as the biggest pitfall. I think we should ensure that the parties are free to engage in a commercial transaction that they deem right, depending on their firms or their organization's long-term needs. And acts like this should not play a spoiled sport. I think that's my only view for now, and I can give in my perspectives on later on.
Sanjay?
Yes, thanks, Sanjay. My view is that, when we sell residential real estate, one of the challenges people have is servicing a debt that they have taken. The only way they could service the debt is through a EMI, a loan, which they do, and pay it back if they're not occupying a property. Earlier, what we had a situation where we would sell properties and then buyers would say, how do we regulate? I don't want to rent it out. I'm not living in the city. I don't know what will happen to my property. Will I get it back? Even if the tenant doesn't pay me the rent on time, but will I get my asset back? Having this kind of a law coming in, an act coming in, will, I think, insulate a lot of those doubts that an average person would have looking at owning an asset, but not really being confident of renting it out. Also, I think what it would do is it would really open up a huge amount of inventory where ready to move in properties are available, but are locked. So you have large buildings where you have so many apartments vacant, and on one side you have a demand, like Harsha was saying, OMR is a very active corridor, so it provides a lot of migrant people who work in that corridor. But when they need housing, I think there are a lot of challenges they would also face on one side with the limited supply and the pressure on rentals. So I think this coming in will certainly bring in a lot of transparency and confidence, both for the tenant as well as for the landlord. I also agree with Asha that the deposit that has been specified seems to be low for residential, and it really may not cover cost if at all there is some damage, or some charges which the tenant has not paid during the tenancy period.
Okay, so the takeaway is, one, it brings transparency, it brings in certainty, it kind of, but the down, and it brings in confidence for landlords to give up their property, because they might, now at least they're much assured that they will get their property back. And the downsides are that, the government is trying to interfere in a commercial transaction to put limits on it, which is not how business is done. So good. Now, Balaji, I know you have registered your lease agreements both under the Transfer of Property Act, that is under the Stamp Act and Registration Act, with the sub-registrar, and also with the Rent Authority under the Tamil Nadu Act. Can you please quickly explain the kind of to the audience the process involved under the registration for them, because you've already done it?
Yeah. So under the Stamp Act, the registration at sub-registrar office, I think last couple of years, they have gone electronic in terms of getting an appointment, but still, the persons who are the signatories of the leases have to be physically present at the sub-registrar office to, attend to the lease registration, get their photographs done and thumb impressions and signature before the sub-registrar, and then document gets registered by paying the stamp duty. So it's a pretty much a traditional process, except that 10-20% of the transaction has been made electronic by using an application 2.0. Now, as far as the tenancy portal is concerned, there is developed by Government of Tamil Nadu. And that is a portal where you go and register your tenancy documents, where you need to enter the particulars of the property, the particulars of the lessor and the lessee, and then submit it along with the payment of a nominal fee to the authority. And the authority in 30 days' time will return back to you with a registered code number for the particular transaction. And an email with a PDF document, a one-page PDF document will be coming back to you, confirming that your tenancy has been registered. So pretty much it is a duplication effort, like what Praveen has also mentioned. But nevertheless, in today's position, both the acts demand for registration. So the lessor or the lessee doesn't have a choice if the period is beyond 11 months.
Your experience, you feel it's a simple, easy process when it comes to the tenancy registration, Balaji?
Well, it is not very cumbersome to say, because when we did the registration, it was immediately after the portal was rolled out, and I'm sure any portal that is getting rolled out will have its own teething issues, and servers getting hanged, servers not working. These were some of the problems which we faced, but it's not really difficult to do it. I'm sure once couple of times people try it out, it becomes familiar to the people.
Okay, I mean, I know it's a relatively new act, but did you by any chance get to use the rent authority or the rent court lately after registering with those agreements, Balaji?
Well, thanks to all my tenants, they didn't give us any such opportunity.
Good. Praveen, your views on registration process as a tenant?
I come back to the same point. Now, typically, we have leases for longer tenures, and being compulsorily registrable under the Registration Act, we go through the hassle of registering it. It is a hassle, as Sanjay, you would very well know. Now, thereafter, to again endeavor to file this Form 1 under the first schedule, in the name of regulation or clarity, that is where now we have difficulties, particularly in these days when we speak of ease of business. Now, this is just adding one more hassle to those long chain of events. Now, I am attracted to Amit's point on intrusiveness. And there is something about this process regarding the intrusive nature of the act as well. Now, under Section 4 of the new act, the details pertaining to the tenancy shall be uploaded on the website post the registration. Now, even under the rules framed under the earlier Tamil Nadu Act, now there were similar analogous provisions. Now, to make such information readily available pertaining to a private parties is debatable. Now, even if I refer to the Right to Information Act, as we know, and information including commercial confidence and that which affects the competitive positions of third parties are barred. So, to what extent can this act really intrude? To second Amit.
Okay, so your concern is, of course, again, the duplicacy, but a lot of commercial information being readily available. But can't we argue this thing that, even in the old act, under when you have to register under the Transfer of Property Act, those information, of course, it's not readily available, but those are public documents, and they can be taken by anyone by asking for a certified copy. So it's there, but yes, it's not readily available, as rightly said. So it's there. You'll have to kind of search more for it and get that going. Okay, Harsha, your views on the registration process, both as landlord, tenant, and as the Resident Welfare Association federation which you're running.
Sanjay, when we started preliminary discussions about this thing, I bounced a question off in our groups. I said, how many of you have really tried this link, that tenancy.tn.gov.in? Answer was 0. Nobody in our groups that I personally know through the groups have tried this. So, I mean, people are mostly residential, so I think it's all 11 months. And then there is a clause in that which says if you don't extend it, it's assumed to be extended, the traditional ways. Nobody has done this electronic thing, even though from 2017-18 it's been there. So 3-4 years, nobody's tried it. We did try it. We went online. We tried to do it a couple of times. I think right now, both the landlords and the tenants' information is required. So then you get into this Aadhaar, you get into the PAN, you get into survey number, you get into all that. So entering all that little cumbersome halfway through. Some of our team members or volunteers, they just gave up. They said, sir, it's too much. I don't want to do all this just to try it. So when I really rent out my apartment, maybe I'll do an effort if it is compulsory. So right now, I don't think anybody thinks it's compulsory. So nobody is trying it. Nobody is doing it.
I mean, the Act says, yes, it has to be registered.
Yes.
People have, I think, people have not landed up in a dispute, so they are still not required to prove the agreement or contract, so they are not looking at it seriously. But if disputes occur and those agreements are then to be proved or to be tested, then you could have challenges. So, okay, we will come to that, yes. Sanjay and Amit again. The Act recognizes the role played by property manager and also lists down the duties of the property manager. Do you think this would help in getting a mandate to be a property manager for you guys in a more organized manner when compared to, let's say, any Tom, Dick, and Harry wanting to be a property manager? Sanjay, you want to go first?
Sure, Sanjay. So I think it's an opportunity to extend the services that we already provide. I mean, there's two ways. One is a broking service where you really interact, get the transaction closed, and then move away from the transaction. But as a property manager or as a service provider, I think it's a great opportunity for all of us, to extend the services just beyond the transaction parts, but to the management side. And I think, like I told you earlier, a lot of the landlords are absentee landlords. They don't live here. And rarely they would like to reach out to their own, friends or family who live in the city to go and, every time solve a tenant issue or, payment of rental or maintenance or whatever issues they have. So I think coming in here, even if there is a fee that is to be charged or a nominal fee that, is to be earned from it, I think it will open up a huge business opportunity for us, especially in the residential space where people do have, apartments, they want to rent it out, but they're looking at the trusted consultant / advisor to manage that part of it. And from the tenant's perspective also, there is some kind of redressal. If there is an issue which they would face, in any form, at least they could reach out and express it rather than saying that I'm not able to do it, or I will do something and then charge it to the landlord later because the landlord is not available. So I think one is it's a service model that can be created out of this. And second is, I think it will smoothen out a lot of the relationship management which happens, the misunderstanding which really occurs between a tenant and landlord many a times.
Okay. Amit, do you want to go on?
I guess I'll just mirror this to more mature markets, if I may, carefully do that. If you look at larger, more established markets, both in the Western and Southeast Asian markets, you will find that conglomerates or this residents association actually prefer to give it to a third-party authorized agency that is competent to actually run this whole program. Obviously, what is listed down as a list of things that needs to be done by the property manager is just the tip of the iceberg. There is far more that actually goes into fulfilling the obligations to balance the running of a particular campus or project. But it's so important for us to actually have that interface who can professionally, in a transparent manner, run this. We have come across numerous cases where very unpleasant conversations by these interface leads to unwanted animosity, and then really unpleasant scenarios of cutting of services. These can all be avoided once you have like a formal engagement with an agency that's reputed, has global standards to go by, has technology tools to go by. To Sanjay's point, yes, it will cost, nothing comes free, but the fact is it smoothens the whole experience, and is so already in about 600 million square feet of commercial real estate already. If you see, all the large commercial real estate projects in the country are managed by professionally qualified property managers, and that's a very, very reputed job in the Western world, and so is in India. And extending that in the residential segment is a prerequisite, I would say, for this industry to get far more formalized and professional.
Okay, so now comes the bad part. In the new act, the rent authority has a right to regulate you guys, your activities, and also levy penalty on you. How do you feel, a regulator on your head? Both Sanjay and Amit. Amit, do you want to go first?
So I think we've always practiced a significant degree of self-regulation already, and if there is a regulatory requirement to meet certain compliance standards, so be it. It's the cost of business, and if that is going to bring about significant investor confidence or significant occupier confidence, then we have to adapt to meet those standards. While I should say most of the organized players already have significant global standards that they go by any which ways, and these are fairly robust than what is loosely worded in this particular act for now. I think we have more than game for that regulation.
Sanjay, your take?
I agree with Amit. Why not? If there is a regulation which is there, don't we anyway have it in most of the businesses that we do? So, like Amit said, it's self-regulated. I too agree with him and echo the same point. If there is a regulation which makes the business model work a lot better, there are more compliances, there are checks and balances. I think if you have a serious player who wants to really, do this in a organized fashion, I think the regulation is not a deterrent. I think it only adds one more level of authenticity to the whole service providing game for the property manager.
Okay, good. So this act was enacted sometime in February 2019. The relevant authorities set up again in mid 2019. Do you guys have any studies on how it is rolled out in other parts, at least in Tamil Nadu and other parts of the country? If any other states have enacted similar laws? Sanjay and Amit, do you have any studies within your group or within your this one?
I don't want to disappoint the participants. It has been abysmally low. Though again, to the point that most of my learned colleagues on the panel have already cited, I think everybody felt the compliance need to go and have a stamp duty registration done, right? Because I guess we are all hardwired that, okay, once you do your registration with the sub-registrar, you're protected by all means. And even though the Tamil Nadu Act has been in effect for some time now, I don't think sufficient education, amplification of the need to go and register, coupled with, of course, the duplicity and the pain around doing duplicate items, and the potential threat. See, as a large corporate, every corporate wants to protect information. They do not necessarily want to go and make data public. Tomorrow there could be any action. Nobody knows. I guess it requires a little bit of that comfort to be given to the parties involved, and a significant amount of amplification to everybody, saying that, hey, if you are not registered with us, if there is a conflict, you can't take legal remedy, right? Today, everybody is of the view that the civil courts will protect them because their contracts are registered under the Stamp Duty Act.
Okay. So just leading one more question. Do you think the states which have enacted a better tenancy law will attract more investments, both in commercial space and housing space? Sanjay and Amit.
As I told earlier, and if I may, just announcing doesn't help, Sanjay, and it is how it is implemented, how robustly the systems are in place to regulate. See, the good thing here is, I was going through some stats, and I hope I'm not wrong. I believe that there is an excess of 4.4 crore cases pending with the legal system currently. And if by creating a rent authority, a rent court, and a rent tribunal, it is going to fasten the process of conflict resolution, then so be it. But to your very point, the appointment of such officials, to competent officials who are available to do this full-time as a job and meet those conflict resolution timelines that are set out, will be the most critical aspect that will encourage people to comply. Otherwise, you will find resistance, you will find dissent among the users to actually, register themselves under this particular rent authority.
Sanjay, your take on this?
Yeah, so if you look at data, it's only 20% of total urban housing that's been rented out at the moment. So there are more than 1 crore homes lying vacant, which have not been rented out. Also, if you look at capital values, if you look at residential space, while the capital values have gone up, the ROI, or the return on investment on a residential lease property, has been very low, 1.5 to 2%, which really is not very attractive as a return on investment. So I think what will happen with the new law coming in, it will also encourage investors to really invest in rental properties or own probably an additional home or so, which can be put to future use. But in the meantime, they know that there is something that is coming out of it as an income if the ROI is attractive enough. I think it will also attract a lot of the private housing companies to develop, rental creating assets in the residential space. Like today, for example, Ramakrishnan's company or Balaji's company, which primarily are more into commercial, would also then look at residential housing as an asset class, which they could build and rent it out and create a sort of annuity income from those assets.
Okay, that's interesting. That's a good takeaway maybe for both Balaji and Ramki. Praveen and Harsha, from a tenant's perspective, do you think the limit on security deposit of 2 months for residential and 6 months for commercial purposes is favorable to you as a tenant?
Yeah, as a tenant, I love it. As a landlord, not so much. Like I said, especially in the OMR bachelors and guest houses and PGs, 2 months doesn't cover it. It's not good. And I want to take off from a little point that Amit made about implementation and regulation. Who's going to do it, and how's that going to be, mandated that we register it? Like I said, none of the people I know in our groups have ever registered this, either online or at the registrar's office. So if we are going to insist on implementation and regulation, it's like a laddu for the bureaucrats. They're going to sit on our heads for that. If they come and tell every RWA, unless you have a registered tenancy agreement, you cannot let out the apartment and you cannot do this and do that. I mean, they just have to come to the RWAs and say that, and then it's doomed. I know if it's retrospective, even worse.
No, but luckily it's a prospective act. But yes, but then for you, retrospective could be 2017 still. So that's a difference, not the value ones. Yeah. Okay.
On the security deposit, sadly, I have to go back on that proposition, initial proposition of clarity and certainty here. There is a lot of clarity and certainty, but I really wonder whether this provision would be useful or whether it would remain redundant. Now, what if during contractual negotiations, the landlord refuses to abide? Now, in the absence of enforcement provisions with penal consequences, now this provision may not really serve any purpose, and then security deposit would still be a commercial decision. Now, as an in-house counsel, perhaps I would be looking at these particular provisions pertaining to security deposit as a benchmark or as a guideline, so that wherever it is advantageous, I can leverage that to be incorporated into the contractual provisions. That's the way I look at it.
Okay.
Sanjay, if I may.
Yeah, go ahead, Amit.
If I may, this is one of a example that I told you. There are many, but this is certainly a very intrusive preposition, because not just does it limit the 2 months, but it also allows the tenant to default payment on a non-consecutive manner. If you read, I'm sure you have done that very well. The action, if any, can be taken only when there is 2 consecutive unpaid rents in a calendar year. And trust you me, while the intention of nobody is to default, but we have had weird cases where we have seen significant repeat offense that's or breach that is committed, and in such cases, having a penal provision of 2 months or 4 months beyond that, you won't get anything in hand, right? The landlord is technically stuck with those provisions. But again, so to my original point, I guess the commercial aspects and the penal aspects of the commercial understanding should be kept out of the act, is my limited view.
From a landlord perspective, both Balaji and Ramki, what is your take on this? Do you agree to that it should be kept out, or because it's very detrimental to you guys?
Yeah, I think I echo both Praveen and Amit that commercial terms should not form as part of the act. It should be left as part of the contractual obligations and the rights between the lessor and the lessee, both in residential as well as commercial. And obviously, those things, if is not met or honored by both lessor or lessee, then there are notices that can be served. There could be remedies, there could be cure. And even after that, if something is not happening, then obviously you will have a legal route to take it forward and have it resolved. So I think my view here will be commercial should be kept aside and it should not be dictated by the act.
Ramki?
The mechanism is already there. The mechanism is already there. We don't have to really touch upon that point in the act. Is what currently with our commercial clients, we don't have any issues, because as long as our document is registered, we don't find it any difficulty. But at some places, I feel that maybe in retail, these type of things might help. We don't know. We need to see one life cycle of something that needs to happen, because we don't know how the advocates will play around and how the judges will play around, and what results we get out of it is also a point to. I would say that we should give it a time. If something is not happening, then we should. Too much defensive is also not. Currently we have all mechanism to just take care of our commercial leasing. While this act is there, we handle so many other sort of requirements as licensing requirements. Doing a building, we have 15 other approvals, 15 other challenges we do, and then again, another act to us is going to be difficult. But it's a wait and watch is what I would say. While I agree to all of them in the panel.
Okay. Harsha, it's a torchbearer of the. Sorry, Balaji, you were supposed to say something. You want to say something, Balaji?
No, I think Ramki has also added to the point, but I think in order to bring in a larger enforcement and make more participation in terms of implementation of this act, I think the process needs to be made as simple as possible and as flexible as possible. I think that is very, very important. reduce the extent of duplication. One. Second is how easy it is for people to go and then just go and put it, or if at all we are doing a stamp registration act, the rent authority should just pull the data from there and then get it registered. You don't need to do it twice typically, right? So something of that sort, government should look at it, make the process simplifiable, and make it more flexible for people, so that people will come forward. It will be more encouraging for them to come forward and do a registration. Today, the psyche of people is, oh, I need to get into the website, I need to enter so many data. Is it really mandatory? Let me see, let me wait and see, what happens, and then take a call. I think that's the kind of psyche which we have been experiencing when we talk to people here. So I think it's more important that, simplification is important, and eliminating duplication it really helps in terms of more participation in implementing the act.
Okay, just before we move forward to the next question, just for the audience, keep asking your questions. And if it is to a particular panelist, do write in so that it's easy for us to identify those panelists for you, to give you the answer. Harsha, as a torchbearer of the OMR Resident Welfare Association, do you think the inbuilt process is overstay? That is twice the monthly rent for 2 months, and then the 4 months which they are saying till you vacate. Will that ensure that tenants vacate in time and kind of, not overstay? What do you think?
Right now, our current worry is to fill those apartments. Last 16, 18 months, everybody is gone home. So we had people from Bihar, Chhattisgarh and all staying in OMR with all your IT boom. They've all gone. They've all disappeared. So landlords are desperate to fill apartments. Yes, if it was full and if everybody was paying rent and you wanted someone to vacate, in that hypothetical situation, yes, 2 months double and then 4 months, 4 times or whatever. That thing makes sense to me. Yes, that would be good to implement. Yes.
Okay. Again, there is a specific bar in cutting off of it or withholding essential services or supply, and the essential services is also defined in the Act. For the Flat Owners Association, collecting maintenance fee is paramount to ensure that these common services are not interrupted. In case either the landlord or the tenant does not pay the maintenance fee, what remedies do you think you have, given that these services cannot be disconnected?
My understanding till now has been that this is governed by the bylaws. The bylaws says that if you do not pay maintenance, then the services rendered by the association can be withdrawn. And that is how we have been operating. So if it says in the bylaws that all services provided, OMR is a very unique situation. I don't think rest of the country really understands this. Why rest of the country? Rest of Chennai. Somebody in Arepuram or Adyar will not understand this concept about water being cut off or water being bought by the association. There we are essentially having metro water connections and life is simpler. But here on OMR, we have to buy water, we have to send out our sewage. We don't have any piped connections. So essentially it's a commercial transaction that the RWA has to get into every single day, buying water or getting the sewage out. So things like this, we don't really implement landlords collecting their rent from the tenants or the tenants paying to their landlord. We don't concern ourselves with that. I'm speaking from an RWA governing council perspective. We are only concerned if we are getting our maintenance. If you're getting our maintenance, you get your services. So whether the maintenance is paid by the landlord or paid by the tenant, we really don't bother. As long as the RWA gets its maintenance, the RWA continues to give the services that it is supposed to give, essentially water, sewage, and genset in our case. So yes, this new law puts a little spanner in the works. We have to think about it, about not disconnecting those services, and we have to do a little more study as to where the error is coming from, whether from the tenant side or from the landlord side, and how we're going to manage that. Yeah, that's where lawyers are going to make some more money. We're going to be confused and yeah.
Okay. Ramki and Balaji, do you think you'll be able to enforce your right of repossession under this new act? Of course, both of you are dealing with a lot of corporates, so you may not have much of a trouble, but just still, I wanted to know, one-off case, do you think this new act will help you get repossession of your properties in case, the word is faster repossession of the properties in case there's a default?
I think, yes, my view here will be yes, because I take the parallel of the Real Estate Regulatory Authority, RERA, which was formed in 2017, and the entire adjudicating officer, everyone is in place, and on and off, we all must be reading in newspapers the actions that are being taken by the RERA and the judgments that have been passed by the RERA or the orders that have been passed by RERA. I think it is relatively fast. If one have to go to a civil court and then get the suit disposed with the judgment, it takes its own time in the legal system today. But I think with RERA, our observations is that things are pretty much faster compared to a normal route that was happening. And, I presume that this act, when they have the rent authority and the appellate and the tribunal, everyone in place, should be relatively fast. Again, it is subject to the number of cases that gets filed into the authority. Now, if there are too many cases, obviously there's going to be time because I'm not sure whether they're going to be full-time officers or part-time officers or what, but then it all has to be seen over a period of time. But in general, I think the process is going to be faster compared to the conventional route. Ramki, your views?
Yeah, I don't see much challenge because we deal with all corporate clients. We are fairly decent people, but we also deal with some retail people in our premises, which could pose a sort of problem to us. But I think so if the authorities are good enough to handle that, we would get a faster solution to repossession our property. So adding on to what Balaji said, that's my view.
Ramki, do you have retail assets like a shopping mall or actually a mall where this could be a challenge, because getting a tenant out of a mall is a challenge. Though they are organized, sometimes they do come in an unorganized way. So do you have any retail assets in your portfolio?
Yeah, we do have, we have about 6 malls in the country. That's the reason I just said that, in the retail business, we would have some challenges because I would not say that, they are unorganized, but at the same time, they are small timers, big timers, everybody is inside the mall. So depending upon their sort of strength to handle the business, we may have the challenges. So unlike the commercial establishments where we have the ITITS leasing offices, where it is pretty much decent, I would say that, we don't get into such sort of legal issues. But of course, yes, in retail business, with given the situation, we don't get the rents for 2, 3, 5 months, 6 months. We need to just adjust with them, make sure that, they also survive, because we survive on them. It's not about, it's mutual, at one point, if they don't occupy our space, we don't get the rental. If they don't do the business, they will not occupy our space. So it's something sort of, where do we start? Somewhere, that's where this commercial intrusions, what Amit and Praveen were saying, that, sometimes it's, that's the one which, we want to benefit out of these type of deals. Sometimes we want to give in, sometimes we want to take it out. And then, that's the strength we operate on. It's not about, so every business is all about, somewhere, you have to give in, somewhere you have to ensure that, you're a bit stricter in whatever you want to do. While authorities are there for everything, what we do business, but how far they are helping us is $1 million question, So everything we get ourselves into, only then things get solved for us, No authority is coming and fixing your issue, You get, these authorities are, making us do another sort of, responsibility. So, giving a fair due to all the systems and procedures, So good governance is good as long as we get the result. If there's no good governance, no result, then any governance is of no use. Is what my take on this. So.
Thanks, Ramki. I think we come to that stage of the program where, we've kind of given all our views.